Hunter Biden and the Biden crime family IRS whistleblower number 2. We don't know the identity of this person, but this transcript is fresh out of the oven. This IRS whistleblower, this person who was on the case investigating Hunter Biden, who was removed, is alleging all sorts of big problems with what the IRS, the FBI, and the DOJ were doing when they were investigating this, including delaying the investigation, covering it up, giving Hunter and Joe warnings about it, and they know that Joe Biden, allegedly, according to Hunter, was even in the room when some of these deals were being done. Here first is the letter that came out from the whistleblower's lawyer. Whistleblower X is the name of this person who is revealing the dirt on the Biden crime family. Comes from ZMF F&J on June 16th. This got sent over to the Honorable Jason Smith on the Ways and Means Committee, also to Richard Neal as well. Now, this is from the lawyer for Whistleblower X. He says, "Dear Chairman, on behalf of my client, Mr. X, I thank you for inviting him to testify recently before the staff. I greatly appreciate your courtesies. Now, after having been given an opportunity to review a transcript of his interview, he would like to clarify and update the transcript." So let's come back to this because we'll read the transcript first and then we'll come back and see what the clarifications are. So presumably there was another letter like this that went over to Congress, and that letter came after the transcript, which is what looks like this. 168 pages. The interview of Mr. X took place Thursday, June 1st out of Washington, D.C. Happened in the O'Neill House office building, started at 9:41 a.m. Jason Smith was there along with a bunch of lawyers. So we've got lawyers for the Democrats. We've got lawyers for the Republicans. We've got the partner from ZMF F&J, which is the same law firm that's representing Mr. X. So we're all in there. We're in Congress. It's a bunch of people in suits. It's a bunch of government people. This is a transcribed interview of an IRS criminal investigator. Chairman Jason Smith from the House requested this interview, saying that you, following a letter sent to the committee through counsel, saying you desired to make a whistleblower disclosure. So this interview is now being conducted, part of our oversight. Could the witness explain your name and state it for the record, please? He says it's Mr. X. Everybody's like, dang, man, that's cool. Counsel for the witness, please state your names. The lawyers, I'm Dean. Lawyer for the committee says, all right, well, and this is the lawyer for Congress representing the congressional committee, the majority, the Republican lawyer, says, all right, Mr. X, on behalf of the committee, I want to thank you for appearing here today. My name is so-and-so. I'm an attorney on Chairman Smith's Ways and Means Committee staff, and I'll now have everyone else here introduce themselves. And hi, I'm here, and hi, I'm John, and hey, I'm Mary, and hey, I'm Lou, and hey, I'm Jim, and hey. All right, now I'd like to go over the ground rules. Now, because you've come forward as a whistleblower and you seek to make disclosures, we're going to give you the opportunity to make an opening statement. Then we're going to go around and take rounds of questions. Majority for 1 hour. Minority is going to have an equal hour, and we're going to alternate. We normally take a short break, but let me know if you need a break in between, okay? Do you understand that, Mr. X? Yes, I do. And so the court reporter can make a clear record. We do our best to limit the number of people talking and try to speak clearly, be honest and truthful. And we're going to take our time. And if you don't know the answer, tell us you don't remember. And if there are things you don't know or cannot remember, just say so. And if you need to talk to your lawyers, talk to your lawyers. Do you understand? Mr. X says, yes, I do. Says, now witnesses that knowingly come here and provide false testimony, you understand, Mr. X, that you could be prosecuted for criminal perjury? You understand that? We could charge you with a crime if you lie to us. Do you understand that? Yes, I do. Penalty of perjury, lying. Mr. X, is there any reason you're unable to provide truthful answers to today's questions? No, there's not. I would like to note that the information discussed here today is confidential until today. As an IRS investigator, I know you understand the significance of our tax privacy laws. I'm sure you know that the law makes specific rules. In your position at the IRS, did you have access to return information covered by the law? Yes, I did. And have you had access to information that you believe may relate to possible misconduct, maladministration, or taxpayer abuse? Mr. X says, I have. And you wish to disclose that to us today? I do. He says, okay. Well, to facilitate this, we've designated different rules, unauthorized disclosures. We value whistleblowers, and we know that you're here today, but that previously an IRS commissioner called Werfeld, he said that when we were talking about whistleblowers, he said, I can say without any hesitation that there will be no retaliation for anyone making an allegation. Now, he says, I know that he said that, but we understand, Mr. X, that you were still removed from the case team. That's very troubling, and we're going to come back to that. So, lawyers for Mr. X, it's your time to make an opening statement. Please proceed. Lawyer Mr. Zerbe he's like, oh crap, opening statements? I didn't really prepare anything. He's like, well, I don't have as nearly as extensive remarks here, but just a couple of points, particularly with the chairman here. I didn't know this guy was going to be here. Holy crap. He says, we just want to note that if the committee, I mean, we made this point, but just to have it, that if the committee were to elect to choose to release the transcripts like we got now, we would ask for strong consideration for his anonymity. Identify him in his role and position, but in terms of identity, please keep that anonymous. All right, the guy's probably petrified, going to get Clintoned. And the second point is, he says, it's just a blanket point. All right, he's going to cover an enormous amount of topics, ranging over a number of years to the best of his ability, but it's going to be a lot. All right, so obviously folks are not infallible on things, but we strive to be as accurate, as complete as possible. Okay, so it's a lot. Now, here's something interesting. Looks like a very short name there, right? Look at that, it's a short name. We've got a short first name and a short, not that we're trying to identify this person, but it's a short first name and a longer last name. It says, and so as was stated, Mr. X is now here. So his first name might actually be X, which is pretty cool. He says, Mr. X. So as was stated, I am a special agent with the IRS, and I'm part of the criminal investigation team. He says, I want to start out by saying I'm coming here to you today after someone from your committee reached out to my counsel to come in and testify. Now, I paid for my own flight to be here in front of you, as I don't live in the DC area. I have not accepted any payments from anyone in coming here. I've got legal representation through my attorney, Dean. He says, I felt it was my duty as a government employee to abide by your request, and I think it's important that all of you should know from my recollection of what happened during the Hunter Biden investigation so that we can learn from it, so we can fix some things so that justice is served, and to create policy so that it doesn't happen again to us here in the future. One thing I know that people would say about me, Mr. X says, is that I'm passionate about my job and my career at the IRS. I always strive to be the most efficient and the best agent I possibly can be. I'm always fighting for justice, and I always try to make sure that we're doing the right thing for the right reason. But in doing the right thing, I found that people will fight me tooth and nail to do everything in their power to protect their own self-interests. So if I get emotional during some of this, I apologize, but this has been 5 years of my life. So what's happened has been difficult. Yeah, so I apologize for that. He says, I'm an American. My allegiances are to my country and to my government. I'm also a gay man. I have a husband, 2 dogs, a home, and a life full of family and friends. But above all else, I'm a human being. My sexuality doesn't define me as a person. It's just who I love. I'd like to say one more thing regarding this topic of sexuality, especially since it's the start of Pride Month. But people have said that I'm gay, and people have said that because I'm gay and that I'm working on as the case agent of this investigation, that I must be a far left liberal, perfectly placed to fit some agenda. This was the stuff that was on social media about me. Now, I can tell you that I am none of those things. Yeah, I'm a career government employee, and I've always strived to not let politics enter my frame of mind when working cases. I've tried to stay so non-political that in the last presidential election, I voted, but had decided to not vote for the presidential candidate because I didn't want to be asked that question in some court proceeding in the future. And I didn't want to show any potential bias. He says, my political beliefs are simple. I'm as middle of the road as they come, but I would consider myself to be a Democrat. When I was younger, I grew up in a conservative household. I also held conservative beliefs, but over time, those beliefs have changed. At the end of the day, I will always vote for love, kindness, justice, fairness, because that's what I believe God would want for all of us. I heard something recently that I think is overly relevant. The eyes are useless when the mind is blind, he says. Basically showing us that you can have the best investigators in the world, but if you don't have prosecutors, if you don't have people willing to pursue justice and are constantly putting up roadblocks, you'll never achieve a resolution. He says, I've been an agent with the IRS since 2010. In 2007, I received my undergraduate degree in accounting from someplace and my MBA from some other place. So my master's is in business administration. And prior to starting my career at the IRS, I was an external auditor for so-and-so. Throughout my career with the IRS, I have held multiple collateral positions, as well as worked a variety of criminal, tax, and money laundering investigations. Over the years, I received outstanding on my performance evaluations and receiving multiple performance awards, and I've also received a quality step increase, which is one of the highest valued performance awards that we have. I was a healthcare fraud coordinator. I worked criminal, tax, and money laundering investigations into physicians, pharmacists, medical billing companies. I have been the affiant of multiple search warrants. I've authored multiple seizure warrants, millions of dollars, all all under my watch. I was a public information officer. I worked as a liaison to the IRS, law enforcement partners. This collateral duty gave me a whole different perspective. The mission of the IRS is clear. We are to investigate potential criminal violations of the tax law, and my agency has worked to show America this mission. He says, Mr. X continues, in November of 2019, I transitioned out of being the public information officer and into the financial crimes group out of DC. We focus on international tax crimes. We're a specialty group. We sit all over the US and primarily work on international tax cases. This was around the same time that I had initiated a criminal tax investigation into Robert Hunter Biden. I'll come back to that topic in a few minutes, he says. But I want to give you guys an example of what I was working on prior to this, so that we have perspective on the differences between that case and the Hunter case. He said, this investigation was the first of its kind, extremely complex. I came in as the second agent. Jason Poole, one of the tax division attorneys assigned to that case, is the same attorney that was assigned in the beginning of the Hunter case. His name is Jason Poole. He was eventually promoted to the DOJ, also oversaw the tax. He says, prior to joining the case, the DOJ tax had approved tax charges, and our assigned assistant U.S. attorney was promoted to judge. After working thousands of hours poring over that case, the decision was made by DOJ tax to change approval to decline and not charge the case. Okay, this guy's working on this case for a long time. The DOJ declines it. He says, I was devastated when I found out, but at the end of the day, I understood. We did everything we could do to try to work and get the case ready for an indictment. I fought hard. I had meetings with leaders of my agency, but at the end of the day, it was a difference of opinion. DOJ tax, they didn't want to set the precedence. So now I'm bringing this up to you just to show you a difference of opinion between investigators and prosecutors. There are sometimes investigators want to prosecute and the prosecutors say no. The captive case and the steps taken in that case were significantly different than what happened with Hunter Biden. All right, he's framing out for us. Look, I know when I work a case hard and I take it up and they don't approve it for charges, I get it. That's not what happened here. Hopefully I can show you that with my testimony. Hunter was not the normal state of affairs. So he says, so I've ultimately made the decision to come forward and agree to your request. Okay, so he's saying Congress is requesting him to come because I believe I made multiple attempts at blowing the whistle internally at the IRS. One of those was an email I sent internally to the commissioner of the IRS. And he says, I was essentially intimidated and retaliated against after I sent that. So this guy's panicked. So the left, and actually the reporter was even asking Mr. Smith about this. So it sounds like you were like fishing for these whistleblowers. Is that true? He says, no. This guy says, I tried to blow the whistle and his lawyers reached out. And so maybe they reached out to him. And so whatever happened, he's now testifying. And I will bring that if you guys want. I can bring that up later. His lawyer says, yeah, we can provide that email, right? He says, and Chairman Smith says, the email between the IRS, the current IRS commissioner? Yeah, the current IRS commissioner threatened me, intimidated me. This is the one that was in the newspapers that was attached to the long letter by Mr. Shapley. But yes, Mr. Chairman, it's within the last 2 to 3 weeks, so yes. And so Mr. X, he's here. He says, so I'm sitting here in front of you right now, terrified. In coming forward, I'm risking my career, my reputation, and the casework that I'm working on outside of this investigation. I believe that the Delaware U.S. Attorney's Office and the Department of Justice tax have a clear target on me and my supervisor's back, and I believe that they are waiting for an opportunity to pounce on us. This guy's petrified. My own agency retaliated against me, the IRS, as I just stated, even after years of essentially being left on an island from them when it came to this investigation. I did not ask to be in this position, nor do I want to be. My supervisor, who I wholeheartedly respect, decided to blow the whistle on how this investigation was handled because his red line was crossed. The timing, so maybe the other whistleblower is Shapley, right? So maybe Shapley is the supervisor. The timing of when he did that was something that we did not agree on, but he felt he had to do it, and I wasn't going to stop him from doing what he thought was right. Mr. X says, I'd like to note that I wasn't present at the leadership meeting on October 7th, that Mr. Shapley and other leaders of the IRS were a part of, the meeting where he made statements about not being in charge. He says, I also wanted to continue to protect the record and my ability to testify as the case agent in the future. But at the end of the day, I worked on complex criminal tax investigations over the last 5 years, and the investigative process is 99.9% done, and we were in the process of bringing the case to an indictment. And I have emails and I have stuff that I can reference that show you that. And since October, the Delaware's attorney and the DOJ tax have pretty much stopped communicating with me and my team. We've ultimately been replaced and removed. I want to make that clear. We were removed and they replaced us with a new agent and a new supervisor. It says, I'm pleased to respond to the committee's request to assist them in oversight. I have reason to believe that there was gross mismanagement present on this investigation. There was a gross waste of funds relating to the tax dollars, and there was an abuse of authority by the DOJ and the Delaware U.S. Attorney's Office. I will present evidence now and later if needed. I will present evidence now and at a later date if needed. And I will leave it to you to make your own determinations based on my testimony and my documents, what they say about the handling of this investigation. Obviously, we haven't provided this stuff to you guys so far, but in providing this testimony, I will prevent and protect sensitive and secret material. I will also strive to protect any spin-off investigations, but I would like to mention something that's very important here. Sometimes I think the excellent work the investigators did regarding this investigation is being overlooked. He says, I've worked with some of the best investigators on this team, some of the best investigators, by far the best forensic accountant the FBI I have ever worked with. Amazing, intelligent people from the IRS, an amazing co-case agent who was there for me every step of the way, who took my calls when I left, when I felt like I couldn't go on with the investigation anymore because of what was being done and the roadblocks that were being put up in front of me. My supervisor, Gary Shapley, Whistleblower 1, best supervisor I've ever worked with in my life. He was someone I could come to whenever I needed an event, someone who always fought with his heart and soul. Even if we didn't agree on the path, I look up to him. But as for prosecutors on the Hunter case, which included the U.S. attorneys from Delaware and line attorneys from the DOJ tax division, I considered a lot of these people my friends, and we spent a lot of time together over the last 5 years. But their conduct since October 2022 has honestly been appalling, and I do not think that they are considering the human impact of the decisions they're making. I've respected their work, but I think they got lost in this type of investigation they were overseeing. Looking back on everything, they had the best investigators in the nation, and the prosecutors were the JV squad, and they weren't up to the task of handling such a big case. They would often slow walk investigative steps, often not follow the appropriate procedures, and they would say that we couldn't do, or we had to wait on certain steps because there were just too many approvals in front of us. Oh no, we can't get that to you right now. I recently heard from another case agent on the investigation that the Delaware U.S. Attorney's Office loves to slow walk cases or overthink everything. They felt this was exaggerated tenfold because of this case, the Hunter case. That agent also said that they had to work with this U.S. Attorney's Office, so they had to keep the status quo. Don't raise any questions or raise any problems. He says, but I was different. I was coming from the outside. I was able to bring up real issues and challenge their arguments, and it was apparent that they didn't like it. It was often met with rolling eyes. They're like, oh, this guy, dismissing my ideas, telling me that they would quote unquote think about it. I started this investigation November 2018, so this was going to go through a kind of timeline of chronology on the case. He says, here's how it went down. I started investigating this November 2018. Got some bank reports. Another case I was working on was a social media company. Those bank reports, so he's on an entirely different case. I started this investigation November 2018. I was reviewing bank records related to another case with a social media company. Those bank records identified Hunter Biden as paying prostitutes related to a potential prostitution ring. Also included in those bank reports was evidence that Hunter Biden was living lavishly through his corporate bank account. This is typically a thing that we look for in tax cases, or I would say criminal tax cases, I should say. In addition, there was media reporting related to Hunter Biden's wife or ex-wife divorce proceedings, basically talking about his tax issues. And I wanted to quote some of the things that were said in her divorce, which had been public record, saying throughout the party's separation, Mr. Biden, referring to Hunter, has created financial concerns by the family by spending extravagantly, drugs, alcohol, prostitutes, strip clubs, gifts for women, leaving the family with no funds to pay for their bills. The party's outstanding debts are shocking. Maxed out credit cards, double mortgages, tax debt of $300 grand. So Mr. X, the IRS agent, he says, this is all the information that I had in my hand in November, so I wanted to open the investigation. I was like, wow, Hunter Biden is crazy. So I began talking with colleagues in my group. They were asking me why. He's like, I want to open a case like this. He's like, why? Why would I want to open up a case like this? Big cases, big problems was the thing I was constantly hearing. Oh no, why don't you spend more time on somebody who's a Republican, not Joe? I responded to say it shouldn't matter the name of the person and whether we work a tax case or not. Shout out to this guy. It should be the merit of the evidence, the allegation, and the clear understanding why we're opening opening that investigation, doing the right thing for the right reason. But after discussing this case with my previous supervisor, Matt Cutts, he made a decision to look into the case further before sending it. He sent it up for a referral. When we get a bank report, a lot of the time, we're able to take the information in that, bring it over to the U.S. Attorney's Office, and say, hey, will you take a look at this? Are you guys interested in potentially opening up an investigation? Cops talk with prosecutors all the time. That's typical. And because we're in D.C., he lived in D.C., we would have taken it over to a U.S. Attorney's Office. So I said, how about I do that? My manager said, no, you can't do that. That's a tax disclosure issue. I said, no, it isn't. I didn't agree with him. I said, there's multiple instances where we do that. It's a normal part of our job. But he was my manager, and I wasn't going to fight him about it. He told me I had to open this up the normal tax administrative way to do it. Speed bump. At this point in 2018, I believe that I was the only agent in the United States looking into Hunter Biden. The only agent in the entire country. That's great. Yeah. This is 2018, so Trump's in charge. I don't know what the FBI was doing back then. Probably, I don't know, worried about Russia or something. So I immediately drafted a criminal tax initiation package, and I sent it to my manager for review. I wanted to provide an example of something that my supervisor agent told me. I want to provide an example of something that my SSA at that time told me, which caused me pause and concern. He says, this is what I recall. But he said, a political family like this, the Bidens, you have to have more than just an allegation and evidence related to the allegation. In order for this case to move forward, you basically have to show a significant amount of evidence and similar wrongdoing that would basically illustrate a prosecution report. So he says, so he's basically telling me that I have to show more than just non-filed tax returns and the information from the ex-wife and the divorce. He's like, but I got everything I need though. What? It's right here. I didn't agree with him at the time. I told him, hey, we have to treat each taxpayer the same. This would be enough for anybody else. It shouldn't matter their name. But he was my manager and I had to do what he said. So after 3 of these initiation packages, he finally allowed me to push this to DOJ tax for their review. So IRS investigator, supervisory special agent, takes this over to the DOJ tax now, saying, I think I've got enough evidence here to establish probable cause. Can you indict this, please? Mr. X continues. He says, so the way our grand jury cases work, or the way that our cases work is when the case is referred from the IRS to DOJ, the case has to go through ASAC and SAC, then they approve it, then they send it to the appropriate jurisdiction. So in March or April 2019, the case went up to DOJ tax. And at that time, look whose name shows up. And at that time, we were told that William Barr made the decision to join 2 investigations together. So at that point in time, I had found out that Delaware had opened up an investigation related to the bank reports that occurred in January 2019, so 2 months after I started mine. So when I found out about their case and was told that we had to merge the 2, I did a venue analysis. He says, okay, well, who should have precedent in this? Like what venue, what location, what geography, what court? I said, hey, the venue's in DC. It's not in Delaware. We got to work this case out of DC. But ultimately, I was overruled. I was determined to send the case, join the 2 cases together, and work it in Delaware so they can get it out of DC. So it was at that time that we had learned that the FBI in Delaware were referring to Hunter Biden. They were referring to Hunter Biden by the case name Sportsman was how the FBI was calling it. So what were the potential issues I saw with working the case in Delaware, says Mr. X? We were working with a small U.S. attorney's office, probably never worked a case like this. Delaware was a state where the subject's father lived, daddy, and the family was extremely well known throughout the state, including people on the team. And when I say team, I mean investigators and prosecutors. It's right in his backyard. Everybody knows Joe. He's been Joe for 30 years, running for Congress. He's been there for his whole life, and vice president. They continue. They say this was later evident by President Joe Biden. Well, he was formerly vice president at the time, having to come into an FBI office on an unrelated matter, and it being joked with the team. They're like laughing about it. There's another issue. A magistrate judge in Delaware made an inappropriate comment at the signing of an electronic search warrant. She had to remove herself. That caused her to recuse herself from the investigation. This set us back additional 4 months. We had to get new warrants and redo everything. All right. So the judge tainted the search warrant. So they had to do it again. Says, I want to correct the record on that and say that's themselves. So just so we're clear on that. All right. He continues, this is just a few of the issues we encountered. At the end of the day, I constantly remember telling myself, there are issues. We got to deal with it. Nothing we can change. Around 2019, I had emails being sent to me and the Hunter prosecutors from my IRS supervisor. His name was Matthew Cutts. From what I was told by various people in my agency, Cutts created memos memos, which we want to know where those are at, which he put in the investigative files regarding the investigation potentially violating the subject's Sixth Amendment rights. He also referred to Donald Trump's tweets at the time. Right to counsel? What is he talking about here? I recall that at one point, I had to go around my supervisor and ask his boss, ASAC, to tell him to stop sending me and Hunter these emails. I was searching media articles on a weekly basis. I was aware of everything. So one of the first disagreements I recall between IRS investigators and prosecutors was the idea of going overt. When we work in criminal tax investigations, there's an IRS policy in place that we need to interview the subject within 30 days of elevating the investigation. I want to note here, there are reasons why we might wait to interview the subject like Hunter, including undercover work, active crimes, continuing, covert investigative steps. But with tax cases, we usually go overt sooner. I thought we definitely would want to go overt for Hunter because at the time of this investigation, Hunter had unfiled returns for 2016, 2017, and unpaid taxes for 2015. And I wanted to put Hunter on notice in the event that he filed tax returns and potentially paid his taxes. In a normal investigation, we would typically advise them, try to get a statement, try to get an understanding of why there were unfiled returns. Sort of puts us on notice, puts them on notice, and preserves the record. So I wanted to do that, but I was overruled during multiple meetings, almost to the point that I couldn't even bring it up anymore. They would get visually upset with me, and I was continually being told we had to stay covert rather than going overt to preserve potential evidence from the FBI side of the investigation. I even offered just IRS agents going forward and interviewing them. Hey, we have a criminal tax investigation. We just want to talk with you. Overruled. So I can recall being assured by the U.S. attorneys and the DOJ that we would still be fine with a potential spies evasion charges because other activities would be similar, including the Arkansas case with Loudon Roberts, which was his mistress, I guess, who he had a child with that Joe Biden won't acknowledge. So spies evasion, it's spelled S-P-I-E-S. Spies is essentially when you have unfiled returns. Normally unfiled returns is a misdemeanor, but spies evasion is a felony. It's essentially stating that they willfully evaded the requirement and there were overt acts present. That's why they were unfiled. Spies, the lawyer spells it, S-P-I-E-S, spells it out, thank you. So we did not end up going overt, meaning out in the open, so that they go up to Hunter and say, hey, and start conducting interviews until after the 2020 election. They started it December 8th. That's very interesting. So he has multiple meetings about this, and they sat down for meetings, same time, 2019, okay? 2019, he says, hey, we should probably bring this to everybody's attention. They don't actually do that because the election's going on and they want Trump to lose, Biden to win. So he says, so I continue on with this. My memory of the events is from May 2019 all the way to December 8th is the date that we went overt. They covered it up for the election. So throughout that time period, we got multiple electronic search warrants, multiple email accounts into Hunter. We got QuickBook accounts. We got Dropbox. We got an Apple iCloud. He says there was the laptop too. Remember that? And with Hunter Biden being a lawyer, all of this information had to go through a lengthy review because he might have client files on there or other attorney-client privilege materials. So we had to go through a filter team, a filter U.S. Attorney's Office. And so they're filtering out attorney-client privilege documents, which I'm sure there are basically none of. And then we on the investigative team would get the documents to review. Throughout this entire time, we're getting these email search warrants. We're reviewing the records. We're working as a team. We're actually bringing in people to do the filter review. We're having bi-weekly meetings. I'm continually saying at these meetings, we need to go overt. We need to go talk to him. There came a point in time where there were some bank reports out there that were going to be released. They were going to include names of investigators from the IRS and the FBI. So with that being released to the public, we're like, look, it's going to out our investigation, okay? So we got to come clean. And I remember there were always times we were always on an impending election cycle. It was always the election being brought up. In early 2020, it was the midterms. I think that Iowa was the first one. We weren't sure what we were allowed to do. It was always wait and see. And then ultimately, so when you say midterms, you mean the caucuses and the primaries for the presidential run? Yeah, no, I'm sorry. I'm sorry, the primaries. Okay. Well, the primaries are coming. We can't talk about it. So we, on our side, were preparing for the day of action. We were trying to establish who were the witnesses and who we wanted to talk to and search warrants. In a failure to file case, which is what Hunter had, that's typically what we do. We get search warrants, go inside the house, see if they're trying to get their returns filed or what happened. But I wanted to go overt. They wouldn't agree with it. So we pushed this up to management. We said, we don't agree with this. We should be going overt. Our leadership team, leadership within my office called SAC, S-A-C, she agreed that we needed to go overt, but at the end of the day, they outweighed us on it. One other thing I want to note, September 4th, we had a conference call, and the DOJ tax and Delaware U.S. attorneys told us essentially that we were, quote, on pause from any overt activities or any activities that could be overt whatsoever. So we weren't even allowed to issue subpoenas. Wow. September 4th, 2020. Gosh, is there anything important happening around that time? September, October, November, election. Oh yeah. So September 4th, to avert any overt October surprises, the DOJ tax and the Delaware U.S. Attorney's Office say you guys are silent. You cannot talk about any of this. You can't even issue subpoenas. Don't talk about it. It says, I have an example of this. On October 20th, right before the election, we're getting ready to go overt the week or two after the election. The election's in early November. We're getting ready to go overt after the election. And we needed to do a walk-by to make sure where Hunter Biden lives. That's totally typical. We go in our general clothes, walk by the residence, see what's going on. Is there Secret Service there? What's up? And in an email to Mark Daly, one of the DOJ tax lawyers, he says, tax does not approve. No walk-bys. This will be on hold until further notice. I have never in my career have had tax division, let alone approve us doing walk-bys or anything like this. Never in my career have I ever had tax division, let alone approve us in doing a walk-by or anything like this, because the entire agency was rowing against him. Donald Trump had to be removed. This guy was causing a pebble in their shoe. So my response to him was, I'm sure I'll get asked. So this is October 20th now, but can you ask for reasons why? Since I think this would still be covert action, especially since the U.S. attorney approved this, why can't I do a walk-by? He responds, well, call me when you're free. Ultimately, we were never able to do a walk-by until after the election. That's ultimately when we went overt, we were able to do the activities December 8th. He says, so it was all delayed, right? And that was all done by design. And we heard after the election, we were talking about all of this stuff here before the election, but they delayed. Another devastating blow came to the investigation when we lost one of the U.S. attorneys to the private sector in early 2020. She was a judge advocate. He was a judge advocate. I always thought in talking with him, he wanted to do the right thing. He would constantly push the envelope. I firmly believe his departure left an impact on the investigation. Now, I've got more examples. I can recall another meeting before the 2020 election in September. We were discussing additional search warrant and subpoenas, but one of the prosecutors suggesting removing Hunter's name from the request. I said, no, I don't feel comfortable removing his name. Another DOJ tax attorney, Jack Morgan, said that doing it without Hunter's name would get us more of what we were seeking. Now, he says, I have never been a part of an investigation where we talked with prosecutors about removing the subject's name for a subpoena. Never seen it. He says, after the day of action, which is where we attempt to do interviews, I had a list of 30 people. I tiered them. I had tier 1, tier 2 people. On the day of action, I had 10 people I wanted to talk to, where we served subpoenas. On December 8th, the prosecutorial team met on a phone call. During that phone call, we talked about a storage unit that Hunter Biden vacated when he vacated his Washington, D.C. office and stored a lot of items in there. That was uncovered through that day of action. On the night, at the direction of Leslie Wolf, I prepared an affidavit in support of a search warrant for the storage unit. And I thought, in looking back at this, that this was pretty telling. So we have an interesting thing that happened here. He says, you need to be clear. Leslie Wolf, who is Leslie Wolf? Leslie Wolf was the assistant U.S. attorney in Delaware. I say to her on December 8th, okay, sending the draft affidavit. I guess I'm happy we drafted this before. I kept the computer language in the warrant in case there are electronic devices. All right, coming up for air for a second. This is a whistleblower who is preparing to go and execute a warrant on a day of action storage unit of Hunter Biden's. He prepares an affidavit for the search warrant because a U.S. attorney told him to do that. Sending you the affidavit. So I'm going to move on to the next paragraph, reading from it. We will work to get this approved ASAP on our end. So please communicate your thoughts. I would like to possibly execute this search warrant on Hunter's storage room sometime next week. I think that's reasonable given the upcoming holiday. He sends the affidavit back. Please fill this out. He fills it out. And he puts in their electronic devices in case he's got any laptops in there. I kept computer language in there so we can go get those. She responds via email. We are getting to work on on this on December 9th, but I want to manage expectations with you regarding timing. It has to go through us, DOJ tax, possibly OEO, definitely Eastern District of Virginia, who has never seen the case before. Layer in the filter requirements in the Fourth Circuit, and it's just not clear it's going to happen next week, even with everyone making it a priority. Did you hear all that crap that she just dropped out in that email? DOJ, tax, OEO, Eastern District, Virginia, Fourth Circuit. So that tells me two things right there, says Mr. X. That David Weiss wasn't really in charge. Obviously not. David Weiss is the alleged Trump-appointed U.S. attorney in Delaware. And it also tells me that I have never had a case investigation to where, if we needed to get records and preserve them, that we didn't do everything in our power to get a search warrant approved and move on it expeditiously. He says, so I guess with the storage unit, we asked them to keep an eye on it and tell us if anyone went to it. But it was highly unusual that I'm being told we couldn't even do it the following week. Can't even get a search warrant. Sorry, it's just we're too busy. He says, so I want to get back to this. So after I sent this, we sent each other these emails. It was ultimately decided by Leslie Wolf to not do the storage unit search warrant, right? Trump gets his house raided with a sniffle at the FBI headquarters. And U.S. Attorney Leslie Wolf, no, you don't get the search warrant. Sorry. So on a phone call, he's like, what? On a phone call, he picks up Leslie, what is going on here? He says, this is just from my recollection alone. I didn't document this in my notes. I said, I completely disagreed with her and that we are not following the appropriate investigative steps to get stuff in storage lockers and that I thought she might be acting inappropriately. He's like warning her like, hey, this is unethical what you're doing. At the time, U.S. Attorney Wolf asked me if we had problems working together now and if I had issues with her moving forward. You see how these people work? This is a typical government prosecutor response. This guy's trying to do a good job. And she's like, oh, are we going to have problems working together now? Are you going to have issues with me moving forward since I didn't grant you your search warrant? That would be a problem, wouldn't it? I am an attorney. I work for the DOJ, you know. I responded at that time that I didn't. He says, no, I don't have any problems with you. No, we can move forward. Jesus, lady, take it easy. Leslie, gosh. So after thinking about it further, I approached them with an idea. U.S. Attorney Wolf, I said, what if we didn't tell Hunter Biden's counsel about the storage unit? He's been given a request for records. What if at the time that he's given those requests for records, he doesn't access the unit? And if he doesn't access the unit, we know he's not complying with that request. So if at the end of the time he doesn't access it, let's do a search warrant on it then. So they send him a records request. They monitor the storage unit. He doesn't go to the storage unit to get the records. They know he's not complying. They say he's obstructing the law. Then they prosecute him. This would basically be a similar pattern to what they say happened with Trump. No joke. She told me she would think about it. So I pushed this up to my leadership. I pushed it up to my special supervisory agent. They all agreed with it. They thought, yeah, that's a great idea. So they called David Weiss, the so-called Trump-appointed attorney in Delaware. David said to them, they called it the blank plan, which must be Mr. X, the Mr. X plan. David Weiss from Delaware says, yeah, that sounds like a great idea. Let's plan on doing that. That's what he told them from what I was told after the call, on the call with David. So I find out a couple days later on a phone call from them that U.S. Attorney Leslie Wolf and tax attorney from the DOJ, Mark Daley, guess what? Guess what happened? They called Hunter Biden's lawyer and told them about the storage location and said that the request for records includes the stuff in there. Do you see? Total dishonest cheaters. So Mr. X has this great plan. Send Hunter a request for records. He's not going to go give us all the records. We know he's got stuff in the storage room. When he doesn't go to the storage room to get the records, that's when we'll get him. Great plan. David Weiss, the so-called attorney who is on this case, leading this case, appointed by Merrick Garland, says it's a great plan. But the underling attorneys who are not even on charge of this case, Mark Daley and U.S. Attorney Leslie Wolf, they call Hunter's lawyers and they notify him. They give him a warning. Tell him about the storage location so that he doesn't fall into the trap. They literally alerted him. So he says they literally went around my back, my idea, around what we had already talked about, and they did something completely different. And I guess because the thing was probably filled with classified documents, for crying out loud, and crack. And I guess it was at that point, there were a lot of things that happened before this, but it was at that point to me that I started to believe that the attorneys in the U.S. Attorney's Office in Delaware were not acting appropriately. They were not following the appropriate steps. We were not a part of the trajectory discovery or the planning of the investigation as we normally are. I know another situation in which activities were being held up by unnecessary protocols. They were not letting me do my job. This is an email about requesting documents. I write in and I say, hey, attached are these documents that I request for interviews I'm planning to do that are out of town. I send those documents to them. Leslie Wolf responds, says to me September 9th, I do not think that you're going to be able to do these interviews as planned, Mr. X. These documents require approval from tax division. At present, Jack and Mark are racing to get the EWC motion on Stewart's desk. Along with the approval, he leaves out the name. Both of these items are higher priority, and we can't pull time and attention away to move these subpoenas through. He gets totally cut off. Appreciate that you're always trying to stay active and do some travel on your end, but we'll be able to get these interviews done when we have a little bit more breathing room. Well, I had planned stuff like this for weeks in advance to prevent this from happening. Hello, I had brought these up on multiple occasions all the way back in August, and now we're being prevented from doing it 4 days before? It's all already planned. He said, this is making it difficult for me to do my job. I don't understand why DOJ tax and senior management is needing to approve every simple document request and or witness interview. And maybe this is a conversation that needs to be had at a higher level, Leslie. I can push these interviews off. Just know that I'm trying to do as much as I can to plan and get these tasks handed down to me accomplished in a timely manner. I discussed with Mark that interviews we had planned for the end of the month. And so again, at the end of the month, and they're just having delays. Emails sent to management with a list of 10 documents with requests to be served. Do they object to these documents? Says, you're the man, I'll fill you in on my issues. This is me further stating that I am sick of fighting for always doing what's right. There were so many instances, he says, these are just a few, where I'm fighting to get document requests. I'm fighting, it's just all, let me think, there's just too many approvals to get done. And then, not only was I having issues with prosecutors, but then I had issues internally with the IRS. I had to go around senior leadership to my director of field operations. That's the person who's fourth above me. He told me that I can come to him at any time with issues on this case. His name is Mike Batdorf. And I was raising issues all along with so many people. I said to him, Mike, I said, again, look, Mike, sorry, September 20th. Sorry, Mike, I hate to bother you with this, but I'm almost at the end of my rope. I think I'm at the point again where I need your help. I have a ton of interviews and travel planned and scheduled for the next 3 months. Keeping on a timeline is extremely important, and I don't want this to continue to be a problem. Now, I don't mind the questions from management, but it feels like they're not listening to me. It felt like they left me on an island. Now, I want to be mindful of the time here to the chairman. He says, well, what, 15 more minutes? He says, yeah, 15 more minutes. He says, okay, 15 minutes, let's finish it up. Then we can take a short break. Go ahead, Mr. X. He continues. So I want to mention one more thing. Mr. X says, I can recall wanting to interview and getting records from Hunter Biden's children and members of the Biden family. There were expenses paid for the children, as well as potential credit card expenditures and Venmo payments, all deducted on the tax return. When I pursued this on October 21st, Leslie Wolf, U.S. attorney, told us it will get us into hot water if we interview the president's grandchildren. That was completely abnormal, out of the question. And it's part of our normal process that we go in and interview people, especially people who are receiving money or receiving payments related to a case like this. So that's just another example of issues like that. And in October 2021, we had what was called a tax summit. We all met together. When I say we all, it's the prosecutors. Jack Morgan was there, Mark Daly from DOJ Tax was there, Leslie Wolf was there, Carly Hudson from the Delaware Attorney's Office was there. And at that time, we decided what charges we were going to push forward in the prosecution report. We all made the decision. We're going to move forward with counts 2014, 15, 16, 17, 18, and 19. And it would be felony counts related to 14 and felony counts related to 18. That was a decision made at that time. Obviously, we've seen the plea deal. It's not that. So I drafted the prosecution report. I spent all Thanksgiving around that time drafting this massive report. Our reports are a lot of evidence. There's a lot of stuff that goes into it. So in November, I drafted the report and went up to our internal counsel. They're called Criminal Tax Counsel. Also went up to our internal counsel. They review it for legal issues, and they actually give a recommendation to our leadership as to move forward or not. They basically give an approval or a declination, and we talk about declining prosecutions here. All along, they were telling me that the counsel attorney was telling me, her name was Christy Steinbrenner. He says, we're good to go on these. I'm going to give you a green light. So green being that you're good to go on those years. Yellow meaning caution. She was telling me that they were going to concur on it. I was hearing that all along. Green lights. Now, they took almost more than 60 days on their review, which is more than they're allowed. They took more than 60 days. And then in February 2022, they end up sending a non-concur. So a declination for all of the years at hand. February 2022, not long ago. And I messaged the lawyer, attorney, Christy Steinbrenner. I say, hey, Christy, what's up? You told me that we were going to concur, that we were good to go. She responded. She said, I always told you it was green, or I always told you it was green and yellow. And I have to look at what the statement says. But basically, she told me what I stated in there, that it was a concur. So it was like one of the first times I was like, well, gosh, now we have these issues with our U.S. Attorney's Office and DOJ tax, and now having issues with counsel. So our leadership ended up pushing that forward, ended up approving it, and sending it to DOJ tax March of 2022. So he says, I want to go to my notes now. February 25th, the IRS sent the prosecution report to the tax and the attorney's office. In my report, venue was proper in DC and California. We didn't even belong in Delaware for tax charges. He says, well, for why not Delaware? Well, for failure to file tax charges, if there are, it's where the subject lives. So if he's living in DC in 2014 and 15, the venue was DC, and he was living in California 16, 17, 18, 19. So it should have been California. So then we have a taxpayer call with Hunter's lawyers. Defense counsel supposed to show up and give them their defenses. In this case, I know they've had 3. He says, all the cases I've ever been a part of, you get one defense counsel meeting. In this case, they've had 3. With the most recent one, they've had 4. So that's high. I've never heard of that in my career. Never heard of it at all. So they have a taxpayer conference. On or about April 26th, they have a second taxpayer conference. At that conference, they present defenses. We're reinvestigating more things. Now, something happened here. He says, March of 2022, we're told, I get a phone call that they are now bringing the case forward to start. Now, I need to ask you a question about how can we go off the record, please? They go off the record. So March 2022, we know that they're going to DC to open a case, okay? So I'm told, this is from my recollection of conversations, I'm told it was sent to the line attorneys from the DC U.S. Attorney's Office. They got my prosecution report, all the information we had on Hunter, and they said, hey, we want to open this case here. The line attorney says, okay, here's the process. We'll get you guys going. So 2 days later, I find out at another meeting while presenting the case to DC that it was denied. We were not allowed to go there to present the case to DC. We were all to rely on the attorneys to go and do that, but IRS cannot go. So then in March, a couple days later after the meeting, I get another phone call. And from my recollection, Mark Daly calls again, DOJ tax lawyer. He says, I think he was a little bit too forward with the information he gave me, but he basically said that now that the U.S. attorney looked at the case, they don't want to move forward with it. DC doesn't want it. Essentially, what he told me is that not only are they not going to join the case, they also told our prosecutors that they don't think that we have, or that we have the charges. So not only was it a no, we're not going to help you, but it was also a you shouldn't bring the charges here essentially either. Can we go off the record? They go off the record, back on the record. So the first impression from the DC's office was, it looks great, here's the process. Didn't sound like they were going to move it or say no, but all of that changed. So this has been very frustrating for me, says Mr. X. But at the end of the day, they're following this normal process, they called it. And so all that happened, and so we're no longer even talking about DC anymore. Now we have the defenses presented, 2014, 2015, and I was having a lot of issues with the DOJ tax lawyers and the U.S. attorneys about 2014 and 15, because now they're doubting it. So we ended up reinvestigating all of it. We ended up looking at the evidence, and we found emails that actually showed that Hunter Biden had planned for what happened that caused him to essentially evade his taxes in 2014. So he was planning for it. We presented this. We dug into it. We figured this all out. And hopefully after all of this, I can go through some of that for you guys. But we dug through this all, says Mr. X. And then we were like, we finally figured it out. This is why this happened. And it felt like the line attorneys weren't even listening to us. They weren't following the evidence. They were saying, well, they provided this defense, so that's the way it has to be, versus us looking at it like, well, no, let's figure out the way the evidence shows us. So there was a heated argument between myself and Jack Morgan, the DOJ tax attorney, where I said, Jack, I don't think you're looking at this evidence appropriately. You're saying something completely different than what the evidence is showing. And he asks another time, do we have a problem here? Are you questioning my ethics? Are you questioning my integrity? Another argument like that. That's what these people do. They scream about it. We saw that from Durham yesterday. I'm offended. That's offensive. How dare you question my ethics? Yeah, we're questioning it. So we ultimately ended up asking for a meeting with David Weiss, the U.S. attorney in Delaware. We were afforded that. And at that same time, so this is in mid-June, we met with David Weiss and all the leadership. FBI, ASAC, SAC, all the people from the FBI, Stuart Goldberg, tax. We all met in D.C. We were able to present the findings about 2014, 2015, and the case. We were constantly pushing David. We were pushing our leadership with, I'm using the wrong word. We were reciting, not pushing, we were reciting what the evidence showed. And I'll show you what the evidence was. Ultimately, what happened is we have a meeting, a phone call. It's in early August. We get a phone call, all the teams on it together. So Leslie Wolf, U.S. Attorney's on there, Carly Hudson, Jack Morgan, Mark Daly. And they say at that meeting that we are going to approve the recommendation for the charges. He says, this is from my recollection. They are going to approve a recommendation of charges for 2017, 2018, 2019, and that the venue for those is California. They were not approving 14 and 15, and if I don't remember if it's included, it's 16. But I want to say that in an email from Mark Daly in August 2022, after his phone call, he basically said, we have 3 upcoming interviews. These 3 interviews for weeks in September. 2 districts, Delaware and Los Angeles, basically saying that they're approving the charges and they are moving forward with it out of California. But we also learned what they gave what's called discretion. This is what I was told from memory. But they didn't get full-on approval. They gave discretion to charge the case, meaning you can or you can't. From my understanding with tax, if they were to approve the charges, California would have to charge the case. So we have one last meeting, says Mr. X, with David Weiss, the U.S. attorney apparently on this case, in early September 2022 to talk about 2014 and 2015. And at that meeting, David says to us, this is from my recollection, that he agrees with us regarding 14 and 15 tax years. They're great. Yes, we investigated it. We figured it out, but he has been getting concerns from the DOJ tax regarding the tax years because they viewed that at a trial, it could affect the later years. That the information regarding the brother's death, the substance abuse, all that stuff, all those things could play a huge role and cause the jury to have sympathy for him and not convict on the charges. Yeah, plus the fact that it's daddy and he's the vice president, the current president. At that time, David is telling us, well, I'm still weighing it. I love 14, I love 15, I want to charge it. They ask him, when? When are we going to charge it? He says, probably end of September. It was kind of up in the air. Then October 6th happens where there's an article. This gets into what happened and we were ultimately removed. So October 6th comes around, I believe the date. Washington Post comes out with an article. In that article, it talks about the difference between investigators and prosecutors. And there are statements that are made in there from Hunter Biden's lawyers basically saying that we're getting a biased view and that threatening us with criminal wrongdoing if this is being leaked to the media. Hunter got agitated, right? His lawyers started hitting back. So October 6th, the article comes out. October 7th was the meeting between David Weiss, and that's where those statements were made regarding David saying, I'm not the deciding official on whether charges are filed. What? David Weiss said, I'm not the deciding official on whether charges are filed? He says he has no authority to charge in California, essentially, is what is told to me about the meeting. That's right, because he only got assigned to Delaware. And when he asked for permission to go to California or to DC, also declined. After that article on October 6th, we have one more interview left. We're still talking with the DOJ. They're still meeting with us. So October 12th was the last interview that we did. I had a phone call. I have it in my notes. But I had a phone call with Leslie Wolf once again. She asked me for the significant case reporting that my manager sent up to IRS leadership. She asked this as part of discovery. She didn't ask for 5 months prior to this. We turned over some discovery. So it's highly unusual, or I've never had it happen where they've asked me for my manager's either emails or discovery. Okay, so they're taking this away from this guy. And it was at this point, I believe things changed with them. They saw some information, or I don't know what it was, but they requested discovery to include emails from the team and emails and documents from supervisors. They wanted to know what this guy knew and what everybody on the team knew. And just so you know, that would be super unusual because imagine if the chief of our agency had to provide discovery in all the cases that we work. It would be impossible. So anyways, so they request the discovery. They're like, what are they working on? Hey, send me your emails, send me all your logs, send me your notes, all of it. Just give it to me. After that, they request discovery. And then what happens? Well, essentially, we get removed from the investigation. We're gone. I sent an email December 7th. Says, so I was informed by my special agent in charge that the meeting scheduled for tomorrow needs to be canceled. Please confirm that's correct. Mark responds, says, David, meaning David Weiss, and Daryl have been in conversation, and that's what we've decided. The meeting is canceled. I will let the team know. So we found out, talking through our SAC, that the attorneys had found, we were always asking for updates. When are we going to charge? When are we going to charge? When we were told that the prosecutors had found some emails that concerned them if they could actually charge the case, that's what they said to us. So at that point, I'm shocked. And I'm like, you guys told me prior to this that these for years are slam dunks. We were in this whole posture to charge. And then all of a sudden they're saying this. Continue to move forward to the end of April. The media articles come out regarding the whistle whistleblower. And I don't think it was maybe 2 weeks later and they go off the record. He says, I want to close with just this. One final thought. I think about all this, the difficult and the grinding path that I and my colleagues have had to take in this matter and how it best could be avoided. I humbly view my role here today and my response to the committee's request to provide the facts as the best I could. But for myself, as I reflect, it is difficult not to believe that appointing a special counsel in this matter is the best way to go forward to give everyone confidence in the fairness of our tax system. While the impression was that the U.S. Attorney in Delaware has essentially the powers of a special counsel in this case, free rein to do as needed, as is clearly shown, this was not the case. We knew that he has no powers. The U.S. Attorney in Delaware in our investigation was constantly hamstrung, limited, marginalized by DOJ officials as well as other U.S. attorneys. I view that a special counsel for this case would have cut through the toughest problems. It continues to make problems for this case. So I would ask that Congress and the administration, after reviewing the facts, to consider a special counsel for this case, as well as consider the appropriateness of special counsel in taking their authority and spin-off investigations that have the same problems. And lastly, I would encourage Congress and the administration to consider establishing an official channel for federal investigators to pull the emergency cord and raise issues when this pops up. I do not want my colleagues at the IRS, FBI, and other agencies to go through my frustrating and disheartening journey. I believe having such a path will strengthen the public's confidence in their institutions and the fair and equal treatment of Americans under the law. Woo! All right, and so that, my friends, was the opening statement for Mr. X, the whistleblower, who is shining light on the Biden crime family. And there was a lot to unpack there. What I think is the most egregious violation that we saw was that the DOJ was literally warning the Bidens about their pending investigation so that they could do stuff to their storage lockers. Not a surprise at all.